Hello and welcome to another roll call video. Today we are going to discuss the First Amendment to the U.S. Constitution and how it applies to contacts with our citizens in the community. As many of you know, there are citizens and citizen groups that are conducting First Amendment audits and are testing officers of our department to determine whether or not the officers will violate their First Amendment rights. One way in particular that these groups are conducting audits is to stand in front of government buildings taking photographs or recording video of the building, the surrounding area, and activity occurring at the building. So let's discuss law enforcement officers' legal authority if contact is made with someone who is exercising their First Amendment rights. First, it should be noted that federal court decisions have generally held under the First Amendment that individuals have a right to photograph or record public buildings and officials visible from public places. So when contact is made with people who are photographing or video recording officers or public buildings, it should be treated as a First Amendment issue. In other words, they have protection under the First Amendment of the U.S. Constitution. So let's look at the First Amendment. The First Amendment of the U.S. Constitution states, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances." Additionally, Article 2, Section 10 of the Colorado Constitution states, "No law shall be passed impairing the freedom of speech. Every person shall be free to speak, write, or publish whatever he will on any subject, being responsible for all abuse of that liberty. And in all suits and prosecutions for libel, the truth thereof may be given in evidence, and the jury, under the direction of the court, shall determine the law and the fact." There are limitations to the right of freedom of speech assembly of which officers should be aware. In order for any law enforcement action to be taken, officers must show that a clear and present danger be present. This means that a police officer must observe a clear and present danger to the health, safety, and welfare of the general public, or a violation of city or state criminal codes before he or she may engage in enforcement action against those involved in expressive conduct or other protected free speech activities. Furthermore, there are some actions that are considered impermissible by individuals engaged in protected free speech activity. They may not actively obstruct the path of people using a public sidewalk. They may not actively interfere with the business of another by use of excessive noise, by blocking entrances to buildings or dwellings, or obstructing motor vehicles or pedestrian traffic. They may not target or focus picketing or other activity toward a particular household or dwelling in a residential area. If the elements of a criminal offense, such as trespass or harassment, are committed by a person engaged in such activity, enforcement action may be taken by the police officer. Individuals may not commit crimes under state statute or city ordinances while asserting what they consider to be protected free speech rights. Having said all of that, however, CSPD policy states that all department members will allow the recording of their activity while on duty. The only exception to this policy is when the person recording is interfering with a peace officer in the performance of his or her duties. Additionally, department members shall not seize or obtain a recording or a recording device without consent, without a search warrant or subpoena, or without a lawful exception to the warrant requirement. Taking photographs or recording from a public place in and of itself does not constitute suspicious activity. So, police officers cannot arrest individuals engaging in protected free speech activity on public property without probable cause or based solely on the complaint of other citizens. It should also be noted that a new state law was passed in 2015 that provided individuals with a right of recovery against CSPD when an individual attempts to lawfully record an incident involving a CSPD officer or officers, and the officer or officers engaged in any type of the following behavior. Number 1, an officer unlawfully destroys or damages the recording or recording device. Number 2, an officer seizes the recording or recording device without permission, without lawful order of the court, or without other lawful grounds to seize the device. Number 3, an officer intentionally interferes with the person's lawful attempt to record an incident involving a peace officer. Number 4, an officer retaliates against a person for recording or attempting to record an incident involving a peace officer. Or Number 5, an officer refuses to return the person's recording device that contains a recording of a peace officer involved incident within a reasonable time period and without legal justification. Officers must realize that none of the above prohibits them from making a consensual contact with an individual who is exercising their First Amendment rights. Officers can speak with a citizen and ask for their identification. If the citizen refuses, which is within their rights, the officer cannot require them to provide their identification. Also, the officer should not detain them absent articulable, reasonable suspicion of a valid criminal violation. When contacting any citizen, officers should adhere to Colorado Revised Statute 16.3.103, which states, "A peace officer may stop any person who he reasonably suspects is committing, has committed, or is about to commit a crime, and may require him to give his name and address, identification if available, and an explanation of his actions. A peace officer shall not require any person who is stopped pursuant to this section to produce or divulge such person's social security number. The stopping shall not constitute an arrest. When a peace officer has stopped a person for questioning pursuant to this section and reasonably suspects that his personal safety requires it, he may conduct a pat-down search of that person for weapons." So to recap, an officer may not detain or arrest an individual unless they can articulate reasonable suspicion or probable cause that the individual has committed, is committing, or is about to commit a crime. If a person is not arrested or detained, the officer may not force the individual to identify themselves or explain why they are exercising their First Amendment rights. Video recording a public building or police activity in and of itself does not constitute a crime or suspicious activity, and according to federal courts, is protected under the First Amendment of the U.S. Constitution. The only exception to this is when the person recording is interfering with a peace officer in the performance of his or her duties or is conducting criminal activity in conjunction with recording police activity or public buildings. If you have any questions or concerns, please refer to one of the following: CSPD Bulletin 529-17, Public Contacts; CSPD General Order 701, First Amendment Rights, Force, Detention, and Arrest; CSPD General Order 1551, Recording of Police Activity, Information, and Records; Colorado Revised Statute 16.3.103, Stopping of Suspect; Article 2, Section 10 of the Colorado Constitution, or the First Amendment to the United States Constitution. I hope this roll call video has been beneficial. Thanks for taking the time to watch, and stay safe.
Bobby, what's up?